Right, that fire alarm suggests to me it's just gone 10 o'clock, and welcome to this hearing, which I now open. And my name, I don't have a card, unfortunately, with my name, but it's Jonathan Price, and I'm a planning inspector appointed by the Secretary of State to conduct this hearing and determine the appeal made by A. Buckley against the decision of East Cambridgeshire District Council to refuse planning permission for the change of use of land for the siting of 10 residential gypsy stroke traveller pitches, each with a residential static caravan and one touring caravan, permanent or temporary, together with access works and laying of hard standing. And the proposal relates to land north of Pools Road, Wilburton, Ely, Cambridgeshire. Could I ask you to turn your mobile devices to silent? I don't know if it's appropriate to turn children to silent, but I don't think we can do that, can we? We've heard the fire alarm, so there's no other tests today. So if it does ring again, it will be the real thing, and you leave the way you entered, following the arrows that indicate the exit, emergency exit. We're amplified, so I'm assuming you can hear me loud and well. So just to tell you what today will be about, it's a planning hearing, which will be a structured discussion, which I shall lead based on an agenda which I've submitted to the main parties and the council previously. So we will be discussing the proposal based on that agenda. And the purpose of the hearing is to enable both parties and interested parties to put all their views to me and help me gain the information I need to make a decision on this planning appeal. So before we start the discussion with the agenda, I will ask who I will be hearing from today, and I'll turn to my left to Mr. Brown, the agent for the appellant, just to introduce himself and your speakers. And you're not calling anyone else. It's we'll see how it goes. Yes, I'm happy to hear from anyone, obviously. Yeah. Might be helpful to turn your microphone on when you speak later. That I think it helps. Okay, and turning to my right, the council's team, if you could introduce yourselves. I'm not sure who's appearing, so.
Yes, so for the council, it's Gavin Taylor, who's the planning officer. That's myself leading this case. And sitting next to me is Shane Luck from Cambridgeshire County Council's Highway Authority.
Right, we do have, I'm aware that the local councillor wishes to speak. Sir, could you perhaps come forward? You might like to sit on that end, perhaps. And I understand you've got pressures on your time, so you would like to be heard fairly early. Is that correct? Yeah. So your councillor. Sorry, I didn't catch that. Yeah, I didn't catch your name. Sorry.
My name is Bill Hunt. I'm a county and a district councillor.
Bill Hunt.
Yes.
And you're on the East Cambridgeshire District Council and Cambridgeshire County Council.
And the County Council, yes, that's correct.
And you will be speaking in opposition to the proposal?
I'm speaking on behalf of the residents who've approached me. This has been going on for some time, and I get stopped in the street and I get exposed to the residents' views, and I consider it my job to come and express those views.
Certainly. Well, we will hear from you shortly.
I appreciate that. Thank you, sir.
Thank you very much, Councillor Hunt. Right, just a few more preliminaries from me. Anyone else wishing to hear? Yes, sir. Apologies.
My name is Philip Pratt, KR80Z. You will find my name amongst the list of those acting for making representations.
Yes.
And I've been asked today to contribute towards the roundtable discussion in any way that I can to explain their position.
Right. So you're speaking on behalf of. Can you summarise that, perhaps?
Yes, it's the owners of Woodlands, Mr. Upton, which is a bed and breakfast facility in the countryside location the site.
I'm missing a lot of that because of the noise is off. So I think that would be very helpful. Yes. I think you'd be more than welcome. I'm sure they will be more than happy for you to sit there. Mr. Kratz, I missed your first name.
Yes, so my name is Philip with one L.
Yeah.
And Kratz is KR80Z.
Yeah, I've got that.
I'm a planning solicitor and I act for Mr. and Mrs. Upton, who own a bed and breakfast and holiday accommodation place that overlooks the site. And I've been asked to represent their interests today.
Right. Fine. Okay. Well, that's fine for you to stay there. I think it's helpful you sit where there's a microphone so we can hear you. Any other people wishing to announce that they wish to speak now? Anyone decides they want to say anything later on, I will certainly let you say what you wish to say. But at the moment, I'm just trying to find out who definitely wants to speak. So it looks as if it's the parties I have sitting at the desks either side of each other. So I'll just finish with a few preliminary points. Filming and recording of this event is taking place. It's actually being live streamed by the council. So I've got no idea who might be tuning into that. But otherwise, if you wish to make a recording or filming of this event, you're perfectly entitled to do so, provided it's done in a way that doesn't interrupt proceedings. I don't often see people filming my events, but perhaps I don't have that star quality, I don't know. So we've got originally had a planning application which was subject to notification letters, and I've read all the responses received to those. And I've read all the responses made to the subsequent notification with regard to this appeal. So I will be taking all that written evidence into consideration prior to making a decision, in addition to what I hear today. I will need to conduct a site visit, which I expect we will have time to do today. I'm just looking at parties either side of me. This can be done in two ways. It can either be unaccompanied or accompanied. I suspect we need to make an accompanied site visit because we'll be going on privately owned land. So if you could give a thought about who needs to be joining me at that site visit. I think certainly Mr. Luck from the Highway Authority might wish to come along. It is feasible to adjourn the hearing and resume it on site, so to speak, so that we're actually hearing evidence on site. Now, that depends on how manageable the situation is and how many people are around. So perhaps we could give that some thought. You could give that some thought. But I will be making a formal site visit. I think it will be accompanied later today. Just to let you know, I do know this area reasonably well, just through life. And I have visited the site informally yesterday evening, just to see what the site was and have a quick look. And I did drive around the vicinity, so I've got an idea of the geography of the area. which I did have a sort of reasonable acquaintance with anyway. I'm not inviting any formal applications for costs, but if any party wishes to make an application for costs, could they notify me of that before we close proceedings in this room? As part of the agenda, there is an item to discuss planning conditions. Just if anyone was in any doubt, that does not indicate that I've made my mind up about the proposal. It is purely standard procedure. So we will be talking about the planning conditions that might be necessary were planning permission to be granted, but that decision is not made in despite that. So we've got a copy of the agenda, which essentially in item 6 sets out the main areas of discussion. So we may be able to move quite quickly to item 6, but they are based on the reasons for refusal, which were twofold. Firstly, to summarise, it's the effect of the proposed 10 gypsy stroke traveller pitches on the character of the countryside in this part of the Fens, and the council alleging that to cause harm in conflict with policies ENV1 and HO9 of the local plan. The second reason for refusal was that the visibility or the arrangements for securing visibility at the site access were inadequate. There was a supplementary concern about, well, a second concern about accessibility to services and facilities by means other than private car. Is that still part and parcel of the council's case, Mr. Taylor?
Yeah, thank you. I think obviously, as the report sort of sets out, I think the council sort of considers that there's likely to be quite high car dependency, but obviously that need in itself not be fatal to sort of these type of applications. I think it was just obviously the point I think the appellant had raised, that it was sort of being convenient walking distance of services, which the council would dispute. But nonetheless, that's not a sort of primary concern in terms of what we're dealing with here today.
Fine. I think, do you have anything to come back on that? I mean, Mr. Brown? Well, we will no doubt touch on this later on, won't we? More than touch on it. We'll discuss it at length, no doubt. Any other planning issues that anyone has to raise other than landscape character and accessibility? We will be inviting Councillor Hunt to speak early, if that's acceptable with the two parties. Otherwise, I think, and indeed, Mr. Kratz, did you want sort of an early window of opportunity, or did you? Right, okay. Well, I'll rely on you to interject at appropriate times. Perhaps if you're raising concerns beyond the two principal reasons for refusal, you could perhaps bring those in, perhaps after we've heard from Councillor Hunt.
So just to explain, my principal concern is with the landscape character and visual impacts. Okay. Yeah. So, but there is a procedural issue and one other planning issue, which is an adjunct to that. So, okay. Well, I look forward to hearing about that in due course. So I think I've covered all the preliminaries that I need to at this stage. So what I propose to do now is turn to Councillor Hunt, who introduced himself earlier. Councillor Hunt, do you want to just provide a statement summarising what reflects your constituents?
Yes, I'd like to make a relatively short statement if I can, sir. I've got a few points to make, and if I was able to do that, that would be lovely.
Over to you.
Do you want me to start?
Yes, please.
Okay. I'm an experienced councillor, and I've been a I am both a county councillor and a district councillor, and these areas have varied over the years, but I first became a councillor in 2005, and I've been a councillor ever since. So I do know this area very well, and I was born and bred in this area. I think there's something that should be explained, and maybe, sir, you already know, but the area we're talking about is called Grunty Fen, and that's been a phrase used all my life. In fact, the railway line used to be known, of course, as the Grunty Fen Express when it went through there. And it's a peculiar situation in that the whole of Grunty Fen, or nearly all of it, is allocated to Wilburton parish. And it's a clear anomaly, as we've got here today, where you've got, it looks, you know, the paperwork says it's in Wilburton. The people in Wilburton have had nothing to do with it, really. It's actually in Wychford. And realistically, if you saw it last night or later today, you'll be quite apparent that it's a Wychford application, even though it is. And it's interesting to know, and I've, as a local member, I've always asked the planning department here that anything that is proposed from in the Grunty Fen area is sent to all 6 parish councils that could be involved. So that means Streatham, Little Thetford, Wentworth, Hadnam, Wychford, Wilburton, and there's 6 of them. So that goes some way to explain why Wilburton Parish Council haven't been too strong on this matter, because it's actually a Wychford state of affairs. And it's interesting to note, and I'm sure you will have done, sir, that Hadnam Parish Council, Little Thetford Parish Council, Wychford Parish Council and Hadnam Parish Council have all opposed, for various reasons, this application. And one of the key points, of course, why they're opposed to this is that it severely damages the landscape and the character of the area. I mean, Grunty Fen was at one time a fen. It's still subject to it's flat, and it has an appeal which we locals call big skies. We don't call it flat. And we believe, or the people who've spoken to me believe, that these 10 plots would severely damage the landscape and character of the area. And I must say, I agree with the views I've been given. And I've had various members of the public approach me and ask me to represent them or represent their views. And in actual fact, Mr. Kratz's client is one of those people who has spoken to me and expressed his opinions, which I'm sure Mr. Kratz will do with more professionalism than I am able to do. I think there will be large visual effects, and I wouldn't be very happy myself to be in have a residence in an area which is subject to flood issues, and that area has to be drained professionally and in an engineering manner. It is potentially in a flood area. There's been concern expressed to me, and again I agree with it, of the damage that this application would do to the ecosystems that exist in this area. And I know that there are people who treasure the ability to go bird watching in this area, and clearly 10 extra pitches on a side of a road that doesn't have any pitches on it would endanger that. 10 plots is inevitably going to mean at least 10 cars, and there's no possibility, they're not sustainable. It's only with the motor car, because there's no possibility of there ever being a bus down that road, except for the county council contracted school buses, which do use that road on a daily basis to take pupils to Wychford College. There's There's no footpath connecting the proposed site to the village, Wychford, but ignore the Wilburton here. There's no footpath, and I agree with the officers at the county council that I think this is a dangerous situation if it was allowed. It's a national speed limit on the road there, and I think heavy weight should be given to the county council highways point of view. That's all I've got to say, sir.
That was all very clearly expressed, and thank you for that. We'll be touching on some of those issues that you might want to join in later, but that means you've done your bit, so to speak. So if we do, had you intended to stay for a while?
If I may, sir, I've got other people wishing to see me. So if I may, I'll exit now.
That's perfectly fine. Are there any, can we make sure that there aren't any questions from Mr. Brown that he might like to put to me, or that may not be covered anyway? And again,
I wasn't expected to be able to question anyone, but
no,
we're having the only points, the landscape issue we will be addressing, to a certain extent, sustainability and whether there is a footpath that links the site to Wychford is an issue that we'll touch on. As far as flooding and damage to biodiversity are concerned, they are not part of the council's reasons for refusal. So presumably the council itself is happy that those particular issues have been resolved.
I might have some questions on flooding and so forth later on, but see how we go. But I'm just checking that Councillor Hunt didn't say anything that you particularly needed to raise with me before he leaves. That's very helpful indeed. So thank you, Councillor Hunt, for that contribution. And we will proceed. So, and a few other things on the agenda. We've referred, it's a standard matter to talk about the plans under consideration, but I think we're aware that the plan is simply the layout of the 10 units and a drawing of the access. Anything to say on the plans? Are they covered in the statement of common ground? Let's remind me myself. It's a change of use application is what I'm suggesting. And that there's no details at this stage of day rooms, Mr. Brown, is that? No. Right, okay.
So to be boring, I do have a procedural question. It's not on the plans, it's on the application form.
Firstly, you're not being boring. That's the whole point of having a hearing. But let me go to the application form in that case.
Well, so what happened was the application form is the standard one that's populated online and then somebody downloads it and it becomes an application form. But after the event, certificate B was filled in instead of certificate A, and notice was served, and it's in the application documents that accompanied the council's questionnaire. Slightly bizarrely, notice was served on East Cambridgeshire District Council as a landowner. And I suspect that there was an error there. It was at a time when the District Council, following, I'm afraid, central government advice, required notice to be served on the county council if they owned any land in the vicinity. And I believe that actually that notice should have been served on Cambridgeshire County Council. Now, the boring bit, of course, is
as the highway authority.
Well, no, as landowner.
As landowner.
Yeah, and although the county council have participated in the application, as local highway authority and as lead local flood authority, nobody in the portfolio department of the county council has been notified. Now, the boring bit, of course, is that under the legislation, you as the decision maker can't make a decision unless there's been at least 21 days notice served on anybody who owns the land as landowner. So I'm not suggesting this is some, silver bullet that's going to kill the thing stone dead, but it is a procedural nicety that would appear to have gone wrong.
And if I may follow up on that, if the land in question were land subject to highway rights, and I don't know if it is, but strictly speaking, that is in most circumstances not land which we own. It is land for which we are the highway authority, but not necessarily the freeholder.
Okay.
The other point that I would make is that the only land affected, if it's owned by the highway authority, will be land within the highway boundary needed for the actual access. If it were a requirement that the local highway authority were served with certificate B for every application, because you have to show access to a public highway in your application, then every application, every planning application in the country would have to be accompanied by certificate B, because inevitably you are going to have to show access onto the highway.
Okay, I'll ask Mr. Taylor perhaps to remind me. It's a long time since I worked in a local authority, but I'm aware of serving notices. But yes, a large number of applications have access onto the highway. In that case, you don't necessarily serve notice on the, require the serving of notice on the county. Say if there's a new house on a highway and it just enters that highway.
Yeah, I mean, certainly I've actually worked at authorities that take a varying approach to that, which is not helpful. I mean, in terms of obviously the consultations that were undertaken, I appreciate that's not necessarily serving notice, but we'd consulted with multiple teams within the county council. Yeah. But in terms of the notice, having just checked that, yes, it does say, as Mr. Kratz has said, it was served on East Cambs District Council. But obviously
your authority doesn't own any land at all.
Not that we're
so that was kind of a null and void notice.
So I guess the question is were the county prejudiced by not being
whether the county should have been served notice as, and I suppose it all hinges on whether the red line of the application actually covers county land.
So I don't know what was in the mind of whoever it was that served the notice, or why, or who prompted them to do it. To explain my position, as Councillor Hunt did, I used to be a local government chief officer. I used to be a chief officer here when I was a boy in short trousers. So I was fairly confident the district council didn't own any land there.
No.
I know the county farms authority own land scattered all over the county. It's the largest farms estate in the country.
Yeah.
And so I simply don't know, but it entered somebody's mind to serve a notice. It was served on East Cambs District Council, which was clearly wrong. Well, no, it was apparently wrong, but I don't know for
it seems to have been wrong.
Certain.
Yeah,
seems to be wrong.
I think,
and I'm speculating that it was because it was highway land. And as Mr. Taylor says, I've come across varying practices. I say, unfortunately, the government changed their procedural guidance about 5 years ago, and there was a spate of authorities requiring notice to be served on the highway authority. It's not every application, because some are contiguous with the highway boundary, of course, anyway. But if extra land is needed, then a view was apparently taken in central government, which I may or may not agree with, but I probably don't agree with, that notice had to be served. And it was, as the representative of the highway authority has explained, if it's simply a highway interest in the land, notice isn't required to be served, but sometimes it goes beyond that. It's simply a procedural nicety, and it would be a shame if whatever happened today fell apart because notice hadn't been served And it may be that notice didn't need to be served, but at the minute, none of us know.
No, I think we need to keep that thought in our minds because we're talking about visibility displays and control of land on that margin next to the road, aren't we? Because that's very much part of the concern.
Well, the land required for the visibility display is within the highway and therefore is under the control of the highway authority.
So they can ensure the visibility by their normal.
They have got powers to keep that visibility display clear. Yes, they have. And I presume regularly do mow that verge. But I mean, the question for you really is, if notice had to be served on the county council, which I would dispute, because in the vast majority of applications, you don't serve notice if all you're doing is showing an access onto a highway. But even if you did, then the question is, has that prejudiced the county council's interests in any way? And clearly we have a representative of the county council as the highway authority at the hearing. So clearly the county council has been aware of the application, they've been consulted on the application, and they've had the opportunity to respond to that consultation, either as highway authority or indeed as landowner, if that's what they are.
Mr. Brown, you didn't put the original application in, I appreciate that, but to your knowledge, does the red line, that's all in your client's ownership, is it?
The red line extends to the highway, as it has to.
Right.
But as I've said, if that were then a requirement to serve notice on the highway authority.
We're into this procedural issue. Should it have happened?
The vast majority of applications would have to be accompanied by certificate B, because every application has to show access onto a highway.
Anything more from the
If I may just touch on one of those points, it's jumping ahead of the agenda because it's something we will obviously come back to, but to comment that the visibility is achievable within the highway is one of the points of contention which needs to be discussed later.
Okay, right. So that has come about through just talking about what the plans were. We've covered the reasons for refusal, which are twofold on the council's point of view. We've got a statement of common ground. Is there anything either of the parties to that statement of common ground need to sort of add or draw my attention to? Otherwise, I will have indeed read it, obviously, and we will be referring back to that. Mr. Brown, have you got?
Yeah. In paragraph 7.5, you'll see that it's been agreed with the council.
I must be looking at the wrong one. Sorry, I'm looking at your statement of case. Senior moment, apologise. Let me get the statement of common ground. Yeah, sorry, apologies.
7.5.
Yeah, got it.
The last sentence. It's been agreed that the appeal site is not away from settlements for the purposes of PPTS. Right. Why that's important is because, of course, what PPTS is saying, Planning Policy for Traveller Sites is saying, is that sites away from settlements should be very strictly controlled. We are not situated in an area where gypsy sites have to be very strictly controlled. That's the first point to make. Secondly, in the next paragraph, you'll see that it's been agreed that the site is not disproportionate in size to Wychford. And you'll see there that that's because Wychford itself is being substantially expanded by development sanctioned by the local plan.
That second point, you referred to two parts of the planning policy for travellers policy document. The second of those, just remind me what the requirement is. Not to. I've never quite understood what that actually means in planning terms, and you might be able to help me there.
Well, it's always been quite a controversial point, hasn't it? Because clearly it cannot be meaning that there are too many gypsies and travellers in the area. It has to be either some physical domination, so that you are viewing the settlement in relation to the site, and the site is disproportionately large in comparison with the size of the settlement. And that will come down to numbers and the sorts of developments that are being permitted in the area. And we have an acknowledgement that in this case, the expansion of Wychford has been on a much larger scale than simply a 10-pitch traveller site.
Do you know off the top of your head what paragraph in the PPTS this is? It's one I've grappled with on previous appeal decisions, but
I think it's paragraph 25.
25, you know.
Very helpful, Mr. Taylor. Thank you.
So
yes, it's a question of do not dominate, really. It's
it's dominate in terms of either physical domination, i.e. being next to the settlement and being of a disproportionate size in development terms. And then the second part of that is avoiding placing undue pressure on local infrastructure.
Mr. Taylor, do you have anything to add on that particular? I know what the reasons for refusal say, but that particular part of the PPTS, but not dominating the nearest settled community.
Yeah, the officer report that accompanies the planning refusal sort of wrestled with that and concluded that it doesn't create a dominating.
Right. Thank you for reminding me of that. Excellent. Moving on. Policy. Well, the policy is the local plan for the district council, obviously, but as we've discussed, there is a specific government policy document for travellers, planning policy for traveller sites, which I'm of course familiar with, and indeed the national planning policy statement. So anything to add on policy? I don't probably think not. I think we're all aware of where the policy lies. Mr. Crutz, did you have anything on policy?
No, thank you. So I think that the range of policies that are relevant are set out in the statement of common ground.
Okay. Do we need to? I know we're not. There's not. This appeal is not contesting the need for traveller accommodation. But is there anything you just want to sort of stress to me with regard to the gypsy and traveller accommodation assessment? I'll start with Mr. Brown and then ask Mr. Taylor.
The agreed position between myself and the council is that the GTAA is out of date. What it was showing, if you look at the totality of the need that it was identifying, was a need for 50 pitches for gypsies that met the definition and unknowns, as far as they could actually calculate the need from unknowns. But you can tell by size of the pitch need, 50 pitches. It's a considerable need in the area. And you only have to look around the area to see the number of sites that there are. And they're obviously going to be generating household growth. So we've got an agreed situation where GTA is out of date. The council cannot demonstrate a 5-year supply of deliverable land for traveller sites. And the council cannot identify any alternative accommodation for the prospective site residents.
Did you want to?
That's paragraph 7.9, by the way.
Right, yeah. Did you want to just say anything more on that position? Because obviously that affects the balance, doesn't it? And the level of harm I might find on the 2 reasons for refusal. Anything to say, or do you think it's all covered adequately in your?
No, I think we've sort of set that case out quite adequately, both in the officer report and obviously the subsequent statement of common ground. Thank you.
Good. Thank you, Mr. Taylor. Thank you, Mr. Brown. I think that now brings us on to the meat of the discussion, which link into the refusal reasons and landscape character and visual effects. Now that is going to be a judgment call, isn't it? I would suggest it's going to be a judgment call. There's no measurements you can apply. Perhaps I could ask Mr. Brown whether you think, first of all, whether there would be any harm at all, and if you thought there was, what degree there might be, and how you might then explain that.
The first point to make is that the council's own policies and national policy allow for gypsy sites to be in the countryside. So clearly there cannot be anything intrinsically wrong and intrinsically harmful in having the traveller site in the countryside outside of an existing settlement. That's particularly the case here because we have an acknowledgement that this site is not away from settlements where gypsy sites should be very strictly controlled. It is in a location which is appropriate in principle for a gypsy site. If you are looking to put gypsy sites into the countryside, it's pretty obvious that you are going to some extent, change the character and appearance of that area of countryside. But some level of change cannot be intrinsically harmful. Some level of change must be acceptable. Otherwise, you wouldn't have gypsy sites anywhere in the countryside. So you have to look at the particular characteristics of the site and the area within which it's located and ask, is this site, is this development so unusual, so harmful that it stands apart from the general acceptability of gypsy sites within the countryside? Is this, in fact, is this part of the landscape even characteristic of the fen landscape which the council is seeking to protect? And actually, it is not typical of the fen landscape. It is very much comprise smaller fields laid out as horse paddocks and enclosed by woodland and other physical features, such as the embankment along the rear boundary. So it's not typical of the fens. In fact, if you go further along Pools Road and look at the gypsy sites that have been approved in the Fens, they are all situated within a typical fen landscape, which is very large, open, arable fields with few trees and few hedgerows. And they're very much more open to view than the appeal site would be. So when judged against the actual location, this is not a typical fen landscape, and therefore is less likely to be harmful to that fen landscape. What the woodland and the hedgerows also do is close down views towards the site, so that from Pools Road, yes, you can see, you're going to be able to see the site from Pools Road itself, but only over a short length of that road because of the woodland. Both, got to think of the direction there.
I did drive down the road.
To the west,
Yeah,
and to the south, you've got substantial areas of woodland in both of those directions. You've got an earth mound to the north. So in terms of prominence in public views, it isn't particularly prominent, unlike some of the other sites in the area. And it's not particularly going to be particularly obtrusive because of that. Even if you were looking from the footpath, which is an elevated footpath along the rear boundary, you're looking again through a hedgerow and down towards the site, but against a backdrop of woodland along the southern side of Pools Road. So you're not seeing the site against an open countryside setting. You're obtaining a restricted view of the site. So my judgment is that when compared with the generality of gypsy sites in the countryside, this is not unacceptably harmful to the character and appearance of this locality.
I'll invite Mr. Kratz in a minute just to sort of speak on behalf of his particular client. But Mr. Taylor, your landscape decision, how would you respond beyond what you've already put to me in written evidence on some of those points?
Yeah, thank you. I think just to start, as Mr. Brown said, obviously the policies do allow for countryside development of gypsy travel sites and other rural exception developments as well, subject to that assessment of harm. And it's, it's matter of fact and degree, every case in its own merits in that regard. Just in terms of going back to the point of paragraph 25, in terms of sort of strictly limiting sites, it's obviously where those sites are away from settlements, but also areas outside of that are allocated in a development plan. So there are sort of a couple of elements to consider there. And I think when we talk about whether it's away from a settlement, you could look at that from visually, transport-wise, etc. So that there are sort of various levels to that. But nonetheless, I think in terms of this particular site, whilst the typical fen landscape is very flat and with field margins, etc., with hedgerows, this site is slightly different in terms of its juxtaposition relative to the village, in that the site does slope upwards. Obviously, because the fen landscape also includes islands of settlements, which obviously this sort of sits right on the bank of that island, so to speak, in terms of how that land rises up. And in terms of views to that site, you'll note from the site visit, there's already quite a degree of established hedgerow around that site. And yet still, particularly views from that east as you approach, from Grunty Fen Road heading south across eastwards, you'll still see quite apparently, though the units on that site, of which we're proposing up to 20 units of here, both static and touring, notwithstanding any day rooms, but also that right of way that Mr. Brown mentioned. But as you approach from the east along that right of way, it is substantially elevated from that site. And whilst there is some hedgerow along the boundaries, again, because of its elevated position, you will still see that site quite apparently. Coincidentally, none of the other sites that are referred to along Station Road, White Cross Road, etc., you can't really gain long-range views of those sites. They're more immediate and short-term. Whereas this site, I would consider, is different in that you can see it from further longer ranges. And that's notwithstanding that a lot of the development that exists, a lot of the sites that exist along Station Road, White Cross Road, etc., and Grunty Fen Road, they're set amongst a sort of a repetitive pattern of developments there. And that's not just traveller pitches either, that's some farm housing, small businesses, and generally more immediately adjacent to roadside, whereas this site obviously extends rearward by quite some degree and obviously elevates, which makes it more apparent from those longer range views. So the council would consider that, obviously having heard the arguments, it still considers that the development of this site, given that there is relatively little around it and views of that site, would be apparent that there would still be significant harm to the character of the area.
So hopefully when we have the site visit, we can go to specific points just to illustrate that point.
Yeah, I mean, I'd be grateful if we could consider certainly that right of way approaching from that east to sort of view that site. Parking around the area may be a little bit difficult, but certainly we can find somewhere perhaps.
We can talk about that a bit later.
Yeah, certainly.
What about the point made that because there's sort of woodland opposite or plantation opposite, that providing a more screening than the more open areas further to the west down Pools Road?
Having visited the site myself, I don't consider the woodland, the woodland itself is it's fairly individual in that area. But obviously the views of this site are more from that Grunty Fen Road along that eastern side. I would agree with Mr. Brown that the site is fairly well screened from along the western boundary there. And obviously that immediate northern boundary, you can't really see into that site. It's quite dense, particularly now, but obviously this is taking into account the sort of the current time of year. We've got to consider sort of the impact, the visual impact of that site throughout the year when it's less verdant.
Mr. Kratz, your concerns link into this. Do you have anything particularly relative to your client? It might be helpful, I think.
Yes, thank you, sir. I do. I'm going to contextualize them as well. And I'm going to go back to the last topic, the need and the gypsy and traveller assessment. Of course, that was slightly unusual. And I think nobody would disagree. It's out of date, if only by the calendar, if nothing else. But when published, and it was an unusual one in that it covered, I think, 9 authorities at the time in 3 different counties, it was playing catch up with the new definitions in the national policy that was only published the year before, approximately, about 12 months to the day, I think. And it was playing catch up. Now, again, I'm contextualizing it because in East Cambridgeshire, it's noted that there were no gypsy or traveller households identified that met the new definition. There were 114 unknowns that may or may not, and 29 households that definitely did not meet the new definition. And the need for up to 40 additional pitches for the unknown households was made up of household formations. And if the national average of 10% were applied, that would result in an arithmetical need, leave aside personal circumstances, for 4 pitches during the life envisaged for that assessment. Now, to contextualise that further, East Cambridgeshire have given permission for gypsy sites in the last, well, indeed in the last 12 months or so. One was granted last year, not 500 metres from this site. As the crow flies, it's a little bit longer by road, on the main A10. It's land west of Saunders Peace, Ely Road, and it was for 3 pitches. Now, in my time as an officer at East Cams, we granted permission for 148 pitches for gypsies and travellers, and the archetypal one was a pitch for a single family. So there might well have been a permanent static and 2 mobiles and a day room, and they were all well screened. They were perhaps on half-acre plots. And by and large, that was the archetypal owner-managed site in the district. And these were quite easy to assimilate into the landscape because they were very limited in size. Boundary treatments could obscure them, and they tended to be in the north of the district, where, as we've heard several times so far, everything's a bit flat and the skies are big. Now, the difference for this particular site is that by local standards, it's almost municipal in size. It's the size of the local authority owned and managed sites, because there are 10 pitches. It's not a single family. It's going to be managed, and provision will be made for others inevitably with a site that has 10 pitches. And because it's that big, although as a 5'10" person standing on the road next to it, if there's adequate screening, I won't see it. From my client's property, and indeed from the island settlement, which is what they call the pre-drainage settlements in the area, it is highly visible. And we know it's highly visible, of course, because some works have already been carried out on the site in anticipation, perhaps, of receiving planning permission. So whereas before, none of the sites in this general vicinity were visible from what by local standards is a hill where my client's property is, this is highly visible. It's incongruous. Of course, there will be lighting, there will be activity, there will be permanent infrastructure inevitably which follows the change of use, and it will provide permanent and irreversible damage to the character and appearance of the area, which can't be mitigated, and it certainly can't be hid by some boundary planting. The boundary planting would have to be giant plane trees about 60 feet tall to make it invisible. But even if it were mitigated from these viewpoints, it's just cannot be hidden. And it's that permanent and irreversible damage and harm to the character and appearance of this particular bit of countryside, which is inevitable. And we say it outweighs the limited harm, because although we can't prove that there's no need for the this development in context, neither can the need for it be demonstrated either. So I'm leaping ahead to the planning balance exercise, but we say that the harm is so serious and so significant that at face value, it can't be outweighed by the benefit. Thank you for that. That was obviously very clearly expressed. So in summary, you did refer to the size, didn't you? And your previous knowledge of smaller sites being more easily accommodated within the landscape without harm. Where do you think would be the sort of the critical points to view this from? You're more than welcome to view it from my client's property. I drive a Mini, and whenever I go there, I wish I drove a giant 4x4, preferably with monster tires. So it would be a careful drive up there. For my part, I'm happy for you to do it unaccompanied. That's obviously a matter for the principal parties. But would Mr. Taylor know where to take me? Yes, he would. Yeah. Yeah. Okay.
Can I come back on?
Yes, please. Yes. Yeah.
The points that are being made by both the council and Mr. Krantz are that you're going to be able to see caravans Mr. Kratz refers to, you can't make it invisible. That is not the aim of planning policy. It's not the aim of the gypsy policies, either in the local plan or in national policy. It's not to hide gyps and travellers away. In actual fact, it's quite the opposite. It is to try to integrate them into the wider community and assimilate them into the landscape, not to hide away. And if it's acceptable to assimilate gypsy sites, or if it's even going to be possible to assimilate gypsy sites into the countryside, then you have to accept that that will be by means of native planting, by and large deciduous planting, so that the views in winter are going to be more open than they will be in the summer. So that seasonal difference has to be recognised in planning policy. Otherwise, as I've said before, you wouldn't be permitting any gypsy sites anywhere in the countryside. As for these so-called long-range views, what we have are short-range views from Pools Road, short-range views from an elevated footpath, both of which will be against a background, a solid background, because from Pools Road, you've got the embankment at the back, you've got housing development beyond that, and industrial development beyond that, which is all visible from Pools Road behind this site. It is not, you're not seeing the development on the appeal site in isolation from existing development at Wychford. From Grunty Fen Road, you are looking westward. And again, you're seeing the site in the foreground. You've got substantial hedgerows, which can be thickened out and you could add tree planting to that. But it's all going to be against a background of woodland planting, again, on an embankment, because there's a raised level around the tip area.
Yeah, I saw that on Pools Road,
Yeah. So you're always seeing the site from these public views, you're seeing them against a solid background, by and large, a wooded background. You're not seeing them as part of an open countryside landscape. As for the size of site, Mr. Kratz doesn't see an objection to the local authorities making larger sites. And in fact, some of the sites, with the other site along Pools Road, it isn't of them in substantial size. It's actually got 2 road frontages. So in terms of size, it's not an unusual size, and it isn't disproportionate, as we know, not disproportionate in size to Wychford. Mr. Kratz went through need. There were 149 households identified within East Cambs. The GTA only managed to interview 29, and the people that carried out the assessment, which was Opinion Research Services, decided independently. So these are not, well, they're not independent arbiters of who is and who is not a gypsy. They came to a decision of who was and who was not a gypsy, And that decision was not subject to any challenge or appeal, because no challenge or appeal was possible. So, but to a certain extent, Mr. Kratz's argument is superseded by the Lisa Smith judgment, because Lisa Smith judgment has found the 2015 definition to not only be discriminatory, which was accepted by the Secretary of State, but also unlawful in the way it was being applied. So as it stands at the moment, you have to take into account all of the need that's been identified. The 10% figure that was used for the local plan has been discredited in numerous appeals. ORS, even before Lisa Smith, ORS had increased that figure to 30%. Other companies that were carrying out assessments were using 40% of unknowns in order to decide on pitch need for those complying with PPTS definition. But now we don't have effectively a PPTS definition because it's been found to be unlawful. So you've got to look at the whole need, and the whole need was for 50 pitches. The local plan allocates sites for 4 pitches, and policy HOU 9 is meant to bridge the gap between those 4 pitches and the 38 pitches that the policy was intended as a minimum to provide. But the need itself, if you take into account unknowns, is much larger than that. So you cannot minimize need in the way that Mr. Kratz invites you to do because of the recent case law. And the views that he's talking about from his client's bed and breakfast, of course, are private views. They're looking down at long range towards the site. So at that range, they're seeing a very wide panorama, which is probably including much of Wychford, to be truthful about it. And it will always be against the background of the woodland on the tip. Thank you.
Thank you for that. Mr. Kratz, you're no doubt aware of this Lisa Smith judgment. But I'm taking it you're just really putting your views in terms of landscape effect into sort of some sort of context, really.
Yeah, as I explained, I was contextualizing the landscape.
Yeah. Okay, I think this is a good time for a break because we've been running for about just over an hour, so I'm suggesting a 15-minute, unless you've got anything burning to raise. We'll have a break and then we can, unless there's anything we haven't covered with landscape. My feeling is, I've heard a good amount, and a lot of it will hinge on looking at the site from agreed points.
Yeah, I think we said that gone into this landscape and the landscape planting in the top, you can see from the layout, there were substantial areas to the left, open, and free from the development. And of course, those areas would be available for additional planning. In this particular layout, I think there is
okay, we'll adjourn now have a 15-minute break, comfort break, and have a cup of tea if you can find one till 11:25. So I will resume at that time. So, 11:05, we will resume this hearing. My thinking is we might be able to complete business before 1 o'clock without rushing things, to enable us to have a lunch break and then visit the site. I'm not tying us to that time limit because I want to hear everything everyone wants to say, but it seems to me that should be enough time. So let's move on to the issue of highways. I will explain what I see as the situation. It is that there's an existing access that's been formed in the central part of the site. From that, you can gain adequate visibility, but the concern is ownership of all the land to maintain that. Am I correct?
Yes, broadly.
But the question that springs to my mind is, other than the county that maintains its own highway fringes, what is there another owner, and what are they likely to do to impede visibility? Was the question that sprung to my mind.
Well, the question is, actually, you have a highway verge and you then have a ditch. And that ditch, or those ditches, are part of the local drainage system. The question is, what's the likelihood of any obstruction being caused within that open area of ditch? If you are reliant on the ditch for visibility, why is that likely to change? Because it's part of the local drainage system. So that's going to be maintained as a ditch. But, and we know that the verge plus ditch is almost 4 meters wide. So if you're trying to get visibility from either 2 meters back from the highway or 2.4 meters back from the highway, it is inevitable that you will have an open area either side to provide you with the required visibility, which is the county council has calculated as being around 145, 146 meters in each direction, which we can debate if you wish, but I'm relatively content with that. It is using a figure for braking distance, which is the desirable rather than the absolute minimum needed for safety. So it's using a higher standard at arriving at 145 to 146. They're using 2.4, whereas on a lightly used road such as this and a lightly used access such as this, you could use 2 meters, particularly because the road itself is 5.5 meters wide, suitable for two-way traffic. And quite clearly, if someone's waiting to turn out, they will be, because it's a dead straight road, approaching vehicles will be easily able to see them. And if they have to nudge out into the highway to get better visibility, if that were necessary, which I don't think it is, then cars can maneuver around that obstruction safely. So there's no reason why you couldn't use 2 meters. But even if you use 2.4, there is sufficient width, sufficient open area with verge and ditch to provide adequate visibility.
Right, well, how do you sort of articulate the county's concerns?
Yes, so if I could, you could perhaps indulge me in rambling for a bit about point of a few principles before I get into the specifics of the site. In terms of access visibility, Pools Road is a de-restricted road subject to the national speed limit, which in this case is 60 miles an hour. A 60-mile-an-hour road requires visibility of 215 meters in each direction, which is outlined in design manuals for roads and bridges. That is the stopping sight distance for vehicle traveling at 60 miles an hour, i.e. the distance they need to safely observe a hazard and brake accordingly. Recognized by virtue of the nature of the road, it is unlikely that the majority of vehicles will travel at such speeds, but they are legally permitted to do so. In such circumstances as a highway authority, we accept visibility being reduced, but that reduction needs to be based on evidence, i.e. a speed survey. A speed survey has been undertaken and it showed an 85th percentile speed of 49 miles an hour, broadly similar in both directions. So I equate that as 146 meters in one direction, 145 in the other. So effectively equal. To touch on the point about desirable versus absolute minimum braking distances. So my view is we should not be designing or permitting highway infrastructure which is at the outset designed to absolute minimums. When it comes to matters of highway safety, we should be aiming higher for new infrastructure. So in this case, a 2.4 meter setback is required. I do not accept a 2 meter setback because 2.4 meters is the typical distance from the front of a car to a driver's eye line. If we were to defer back to the design standards, which is design manual for road and bridges, they actually advocate a 4.5 meter setback, but in this circumstance, that is not considered appropriate by the highway authority, whereas we would accept a 2.4. So effectively a 2.4 meter times 146/145 meter visibility splay is required. Visibility splays need to be contained within either the extents of the highway, i.e. the land maintained and under the jurisdiction of the highway authority, or the application boundary, which is the land under the applicant's control. Highway boundaries are not green shaded plans. They are an evidence base compiled of historic mapping, observable features, and that plan is a representation of that evidence base. It's important to note that that plan, that applications based on that will be procured from the county council is based on ordnance survey mapping. That has a margin for error associated with it, but also it's an aerial survey, which is devoid of many of the features which form important parts of making that highway boundary. The typical example being roadside ditches, where there is a ditch adjacent to highway. The common law presumption is that
Can you just try and speak up a bit? I'm straining.
Yeah, sure.
You've got your microphone on, but even there, just speak a little slower and a little louder.
Sure. So in terms of the highway boundary and roadside ditches, the common law presumption is the highway extends to the near side top edge of that ditch, and the remainder of that ditch is under the riparian ownership of the adjacent landowners. In the case of the site frontage, that ditch is owned by the same freeholder who owns the adjoining land. My query is the 145, 146 meter visibility splay has not been demonstrated to be fully contained within either the highway boundary, i.e. the near side of the ditch, or land within the application boundary. The original submission included 215 meter visibility splays, which is what is relevant to the speed limit, and that did not appear to fall within the highway and or application boundary, but no plan was presented which showed revised visibility displays. So in my view, the applicant has not yet demonstrated the appropriate visibility commensurate with the observed speed is achievable within land under the highway authority's control or their own control.
That's very helpful. So in terms of what could, in practical terms, could be a problem would be the riparian owner of the other side of the ditch allowing sort of vegetation to grow up above whatever, you know, over a couple of meters, say, and blocking visibility.
Yeah. Yes.
probably not a question for you, but I just wondered who maintains that ditch, if it's part of the drainage infrastructure of the area.
It is possible. My presumption is it's the riparian ownership of the adjoining fields, but I cannot confirm that. Absolutely.
So you've done a speed survey, and so the actual speed, although it's controlled to the speed limit of 60 miles per hour, it's going to, your evidence is that people will be travelling around 49.
Yeah, I mean, that's not our evidence. That's the evidence submitted by the applicant.
On their survey, and
Yes.
you accept that?
I accept it.
Yeah. I think that sets the scene from the DMRB requirements. I understand all that. Should we let Mr. Brown come in?
Well, firstly, DMRB, this site stopping distance is not 215 metres. That is a distance required for a vehicle to pull out from a side access, a side road, and to accelerate up to speed without affecting the speed of traffic on the trunk road. It is not a site stopping distance. It will, of course, incorporate the site stopping distance because it's actually much further than is required for stopping. The reason for the calculation in my evidence, applying DMRB parameters to the site stopping distance formula in Manual for Streets, was to show that 215 metres is not a site stopping distance. In actual fact, for 60 mile an hour, it's far less than that. Can't remember what I said now. 151 metres, which was applying the 0.375 deceleration rate. As far as what is desirable and what is needed for safety, the absolute figure wouldn't be included in government guidance if it were unsafe. So when looking at highway safety, then the absolute figure, 0.375, is acceptable. Say it wouldn't be in the standards if it was not an acceptable standard. And as far as DMRB is concerned, DMRB does accept the use of 2 metres as the setback distance for lightly used accesses. And that, of course, is onto a trunk road, not onto a lightly used road such as Pills Road. But I think you will need to look on site at the visibility that you can obtain from the site access across the highway. There was a measurement in the traffic survey of the width of the verge, and it was about 1.7 metres. Because you're basically looking at a triangle, so you've got 2.4 metres back is the X distance, 146 metres as the Y distance. You've got a hypotenuse between the two, linking the two. So as you go further, the distance, the width of that triangle decreases in proportion to the length. So if you start off at 2.4 metres, it means that after a third of that distance, you'll be looking at about 1.8 metres. So that the width of the verge needs to only needs to be 1.8 metres, and we've got 1.7 metres. And if you look at the length of verge, or length of ditch, which is within the appellant's ownership, you'll see that it's actually about 57 metres in either direction from the centre of the access. So by the time you get to outside of the ownership of the appellants, the highway verge is actually wide enough to provide you with 150 metres or 146 metres visibility.
If I may come back on a few of those points.
Yeah, please do, yeah.
I take no issue with the principle that as you get more remote from the access, the visibility sway tapers to a point.
Yep.
The point of my objection is that it has not been demonstrated within the application. It is merely that they haven't demonstrated that the necessary visibility is achievable on any of their submission documents. To touch on a few of the other points you mentioned, I do dispute that stopping sight distances are a matter of safety. If a vehicle pulls out of an access, it is required for oncoming drivers to have conspicuity of that vehicle who pulls out into their path to give them appropriate time to stop and react in a safe manner. That is particularly of note when slow-moving vehicles enter the stream of traffic, as would be the case of touring caravans. And not that I wish to get into.
Doesn't that, it sounds to be a little bit more trunk roady, if you don't mind me saying so. This is an uneven road. You're not going to be, most drivers wouldn't be going too fast, I wouldn't have thought, for safety reasons, because it, you know, it's a typical fen road.
No, absolutely. So we know majority of drivers.
You know, what is the scenario? I can imagine on a trunk road, you want that particular ability to sort of enter the stream of traffic and avoid an accident. How does it quite equate to this more rural?
We know through the speed survey undertaken that the majority of drivers, i.e. 85% of drivers, are doing 49 miles an hour on that road. So the visibility which I would require, 146 meters, is the necessary distance that a driver at that 9 mile an hour speed would require to safely stop if something pulls into their path. That reduction from the 215 outlined in the DMRB is a reflection of the actual speeds in this location.
Right. And that can be provided, but it can't be guaranteed because it's, I'd like to.
I don't know if it can be provided because it hasn't been demonstrated by the applicant.
Well,
is this something we can stand around a drawing on site and explain?
We can, and I think that's going to be worth doing at the site visit. But as I said, in theory, if we know the depth of the verge, and we know that it's the width of the verge needs to only has to decrease the further you are away from the access, then within the ownership of either the appellants or the highway authority, we've got enough frontage to reduce that width down to the width of the highway verge.
Right. At the site visit, I'll have closed the hearing. So when we look at a plan and this is pointed out, it will just be referring back to the evidence that we've heard today. But I think we will need to just stand with you there and Mr. Brown there just to.
By all means, although my hesitance is if a 140 meter visibility is required, it is difficult to ascertain that's possible on site. I don't have a tape measure that's 146 meters long, so a revised drawing is probably the more appropriate tool.
We haven't got revised drawing.
I appreciate that, hence why I'm saying.
I appreciate we're not going to have a trundle wheel and you're not going to go out there and tell me when we get to the point, but you know, it will become an assessment I make.
next to the highway, but it's going to be maintained by a highway authority. So, and then you've got open water. And then you've got open water. So even though it may not be in the ownership of the highway authority, there is little, if any, possibility that there will be an obstruction within the area of the ditch itself.
So can I make an observation if I'm allowed?
Please, it's
Yes.
a hearing and do come in. Yeah, I was going to
Well, it's
give you
two
an
observations,
opportunity,
actually.
but
The first one is that the observation is that the knee bone's connected to the ankle bone. And by that, what I mean is my clients are particularly concerned about the incongruity, if I can even say the word, of in the landscape. The problem is that if visibility splays of, be it 2 or 2.4 or 4 meters by 146 meters are maintained,
Yeah.
we've all seen what happens. There is a further incongruity because there is a need to maintain that, and hedges, which may well grow and they become 2 meters, then 3 meters and 4 meters wide, get trimmed back. And it's introducing an alien feature in landscape terms in order to comply with the highways requirements. And that is my observation. The other thought is that it has occurred to me that there's a possibility that the drain is an award drain, in which case under the enclosure awards, it would have been awarded in ownership terms to East Cambridgeshire District Council. That might well answer the mystery as to why Mr. Carruthers, and I for one am very sad he's not here because I've never actually met anybody called Carruthers, and it would have been a first for me. That might explain why he felt the sudden urge to serve notice and certificate B on East Cambridgeshire District Council. As a side product of that, there are peculiarities about being able to cross an award ditch, which I'm not even going to go into here, but there are procedural niceties that may inhibit that. But that's it.
no, thank you for those observations. And I've factored into my thoughts what you've said about, the fact when you engineer a entrance that involves splays and vegetation being removed, and what you're saying is that's part and parcel of your concern in terms of the effect visually of a development. You've made an interesting point about this being an award drain and possibly that being linking into why the notice was served on the district council. Do you have any more points on access, or
not on
leave it to the
yes,
respective?
it was the knee bone
experts.
connected to the ankle bone issue.
Yeah. So turning to the county council again, I think the question I need answering, Mr. Luck, is what's likely to happen once the visibility's been on the other side of the drain, in that far part of the visibility splay beyond the ownership of the appellant, what's likely to take place?
No, I agree with that conclusion. It's from my perspective, I'm comfortable with what I consider to be a necessary safe visibility display. It has not been conclusively demonstrated that has been land under control of the highway authority or the applicant. However, if it does stray into third-party land, the question is what happens to that land in the future, and is there a likely scenario where it is maintained free from obstruction in the long term?
So what you're saying, if I can understand it, is your job's not to speculate what might happen. You're saying that this is the display required. If it's not in the ownership,
From my perspective,
if you're going to speculate on what happens in vision displays generally as a highways, in practice terms, you're going to be wavering. Is that what you're trying to tell me?
It's a can of worms, so to speak. Hence why the requirement from our perspective is that visibility displays are contained within the highway boundary or the application boundary, because it gives us certainty that
Yes,
it is controlled by us or the applicant.
So what you're saying is, notwithstanding that uncertainty and likelihood of what could actually happen, you know, from your point of view, you have to say what your standards are for safety.
Yes.
And, you know, then I suppose it falls on judgments and
Yeah,
so forth.
in usual case, we have
Yeah.
the fortunate position of making a recommendation and defer to our planning colleagues or yourself in this instance to make the ultimate decision.
Right. Mr. Brown, any more from you?
Just to make the point that within the highway verge, the county council not only has powers to keep visibility displays clear, if any overhanging vegetation, if any vegetation overhanging the highway verge, they can also require that to be kept clear as well. I think it's section 270 of the Highways Act. So they can either require the owner to do that work, and if the owner doesn't do it, they can go in, do it themselves and charge the work to the owner.
Mr. Luck, in practical terms, how does your department manage its requirements for ensuring visibility? Because it's presumably a big agenda, isn't it?
Yeah, in practical terms, it is very resource constrained, unfortunately. Yes, we do have powers to remove encroaching vegetation where it causes obstructs visibility. In practical terms, due to staff resources, budgets, that is reserved for critical scenarios, typically where it affects the most number of people. In reality, we do not have a resource to day-to-day manage the visibility for each access onto the highway network.
Mr. Taylor, you looked as if you were wishing to say something. No, it's just looking very alert and professional. That was all it was. Anything more to say on highways? I think
I'd only touch on, there was a second comment about the size of the turning provision within the site.
there was indeed, yes. Thank you.
Some vehicle tracking has been provided to evidence how that operates. I don't accept that tracking because between movements, the vehicle jumps from position to position. In my view, a turning head needs to be larger to ensure realistic design vehicles do not need to reverse out the site. However, from my perspective, that is something that could be conditioned.
So you're not satisfied with the turning space within the site?
As shown currently.
As shown, but you would be comfortable with a condition to that effect. All right. Anything to say on the culverting of the ditch or anything like that?
Well, we'll clearly need consent for said culvert, not from the Highway Authority, from the Drainage Board, but I have no safety issues relating to that culvert.
No. So we're going to have to talk about some of the conditions when we get to that. Any further points, Mr. Brown?
Not other than that there was no objection from the Internal Drainage Board.
No, I noted that. Well, when we have the site visit, we'll be looking closely at the access, obviously. We won't be taking precise measurements. We won't be discussing or introducing any new evidence, but there might be looking at a plan together and pointing things out so that I'm satisfied I understand on site what we've been talking about today. Good. Okay, can we move on from highways and see where we are on the agenda? Did you need to say, I think we've covered to a degree the accessibility. Well, how much more do we need to say on accessibility in terms of car dependency? I think you intimated this was kind of a somewhat of a secondary highway point.
Yeah, I think it was really just to essentially just challenge the applicant's assertion that it was sort of accessible by foot, you know, conveniently to services which the council would dispute, but nonetheless whilst that may carry some negative weight in council's opinion, obviously that's not the most critical aspect
not
of
the
what
linchpin of
we're juggling
your
with here.
refusal reason. Mr. Brand, have you got any sort of general point on that, or do you feel you've covered that already?
I think I've covered it pretty well in my evidence, but
Yeah.
Just to make the point that there is a public footpath running alongside the rear of the site to which we could get access and which gives access to Witchford. But of course, walking isn't the only means of transport available to us. Cycling across a flat landscape such as this is clearly a sustainable option. But sustainability does not mean an absence of car travel. Sustainability can also be achieved by minimizing car travel. And you minimize car travel either by replacing it with other means of transport or restricting the length of trip required. And in this case, the trip length required to gain access to services in Witchford and Ely are relatively short, much shorter than the examples that I've given to you in the appeal decisions that I've provided you with. But there is no requirement in either the council's gypsy policy, HLU 9, or planning policy for traveller sites for access to gypsy sites to be via means other than the private car. And the NPPF recognises that there's a difference between rural areas and urban areas as to the availability of alternative means of travel. And that has to be factored into judgments about appropriate locations for gypsy sites. The vast majority of gypsy sites in this area are considerably further away from settlements than this site.
Okay. Oh, that one, yes, I've looked at that. I was just loading it up. Okay. Yeah.
So all along here, they're travelling show people's sites.
Right. Okay. Mr. Kratz, do you have anything more to add on access?
No, thanks.
No. I do want to briefly just, if we're done with access, briefly touch on flood risk, if I may. Mr. Taylor, are we absolutely, obviously this is a zone 3 high flood risk if you look at the EA maps online, but in this case, just tell me what they're actually saying in terms of flood risk.
Okay, so the site, as you say, is identified in the EA's latest mapping as being in flood zone 3 for fluvial flooding. The EA, however, subsequently confirmed through the life of this application that the site's not located within an area of tidal or fluvial breach hazard mapping. So on that basis, I think it was, yeah, they said it was nearly 4 kilometres away from the nearest sort of river. So therefore the source of that risk, and therefore didn't consider it was an issue on that regard. The site is at risk of some pluvial flooding, so surface water flooding. And obviously the whole area, the Fens in general is managed through a managed system on the drains. We did approach, both the applicant and ourselves approached the EA in terms of additional mapping they may have, hazard mapping in terms of some of that surface water flooding, to see if there's any further detail in terms of flood depths, etc. But there's been no modelling done at this stage by any of the internal drainage boards, which I believe is Little Downham Drainage Board, I think, Little Port and Downham, sorry, Drainage Board. They haven't actually undertaken any sort of hazard mapping, so they couldn't obviously confirm.
But I've got all the evidence
otherwise.
I need to.
So I think the bottom line is that sequentially there is no other sites available, as we've said. Obviously, we've not got a supply, and the EA are not objecting to the site on in sort of hazard grounds, obviously having regard to the PPG, which would generally try and resist caravans in areas known to be at high risk of flooding. They've confirmed that according to their mapping, it's obviously not at a high, it's a residual low risk of flooding from fluvial sources. And obviously the site benefits from some management of drains around the area. So it's anticipated that, should an event occur that obviously subject to the IDB doing their job, which obviously they've got an obligation to do.
They've got to maintain their
then the site should not be at significant risk of high velocity deep flooding, so to speak. And therefore that could be managed through an evacuation plan if need be.
Well, I suppose a lot of this applies to the Fens kind of generally, isn't it? Because in a sense, the whole area is at flood risk because it's very low lying, but it's an artificially maintained.
Yeah, it relies on a managed system of drains.
A managed system.
Obviously, we would normally expect a sequential test to be agreed in advance, but obviously we're in a position where we can't demonstrate there are other land available for this development.
Okay. Mr. Kratz, did you have anything on drainage?
Yes, sir. It's something I was going to touch on. I am discomforted because although the technical information provided, it seems to me, addresses, and it's a matter for you whether it addresses satisfactory or not, the exceptions test. I, on my client's behalf, am not completely satisfied that the sequential test has been passed. And I say that because the preliminary work for what became the local plan 2015 identified a number of other sites. This particular application is described in its covering design and access statement as being speculative and market-led. So if there was an identified need, and I say I'm still struggling with that one, but I accept the fact neither is there a demonstrable lack of need, but the options such as densifying the existing municipal sites have not been even thought of, and the sequential test such as it is, for example, missed the 3 pitches that were given permission within half a mile of this site just last calendar year. And I'm not happy that if I had to defend this proposal as having passed the sequential test and then we move on to the exceptions test, that we're out of the woods on this sequential test. And my starting point is that as an absolute, it is clearly 90% of the site is in flood zone 3, and the Environment Agency's slightly disingenuous response on that point alone was that this sort of development is not compatible with flood zone 3. Well, we all know that because it's a highly vulnerable form of development, that as a starting point, it shouldn't be permitted. And that's just the starting point. I say, it seems to me then that we've leapt ahead to the exceptions test, and you would have to secure an evacuation plan by condition. It's already beginning to sound to me like it's, if it doesn't sound right, it probably isn't right. And I'm discomforted.
So what you're essentially saying is that, in your view, there would be sequentially preferable sites, although they're not identified necessarily.
Yes, and that exercise has not been done as comprehensively as a decision maker should require.
Okay, well, that's something I need to sort of have in the back of my mind, isn't it? So, Mr. Brown, do you want to?
Well, we've heard speculation about there being sequentially preferable sites, but actually no evidence that there are sequentially preferable sites. The council's view is, and they're in the best position to know, that there aren't any. The other thing to consider is that the requirement is to be safe for the lifetime of the development. The lifetime of the development is 100 years. So we're not looking at any longer term than 100 years when deciding whether it's safe for its lifetime. And clearly, the Environment Agency, given the flood defences that are in place in this area and the drainage scheme that's in place in this area, and in fact, all over the fens, that is sufficient to protect this site for in excess of 100 years. So quite clearly, the Environment Agency and the IDB are happy with this, that this development can proceed. If you were going to rule out sites such as this, particularly one which is actually obviously on the fringes of a flood area because part of the site isn't even in the flood area, you'd be ruling out having gyps sites anywhere in the fens. And that's quite clearly not the case. There are numerous gyps sites within the fens.
Fair enough. Thank you for that. I will have to look at that evidence and, having heard what's been said, give it careful thought. But I appreciate that what the council said, and its flood risk does not form part of its own reasons for refusal. Are there any other planning issues? Perhaps I'm looking to Mr. Kratz, that haven't been aired. That you think?
Has been aired, and I'm not suggesting anything other than that. The cigarette company's weight for their weight to be attached with the written ministerial statement the Jonathan Devine provision.
Oh yes.
It's in the written statement. I'm not predicting that it's silver bullet that any use to attach any weight to it, but likewise it's something that should not be ignored. And reminding you it's in the written works.
Thank you for that. You need to turn your mic on.
I'm struggling to know what development has been carried out that is unlawful, because there's been no residential occupation of this site. It's been turned into paddocks, subdivided into paddocks, and that subdivision, as far as it included any operational development, that took place 6 years ago. So even if it were unauthorised at the time, it's lawful now.
Thank you. I think Mr. Kratz wasn't labouring that, but he's just reminded me of that written ministerial statement, and you've just qualified one or two things about what's taken place on the site. Any other planning issues? Anything anyone feels we haven't covered? I put on 8 scheme benefits and planning balance. Let's ask Mr. Kratz, did you have anything particular linked to your concerns?
So I've already said that from my perspective, my professional perspective, there will be a significant, permanent, irreversible damage to the landscape character. We've already heard that the development is only temporary because it's only for 100 years apparently, whereas the damage would be permanent. In all seriousness, though, I genuinely believe that the benefit of a speculative market-led proposal such as this does not outweigh the significant harm.
Mr. Taylor, do you want to just sort of sum up on how you've carried out the balance?
Yep, thank you. So,
or how you feel I should be carrying out the balance?
Just before you do that, can I just make something clear that it's being said, and perhaps Mr. Carruthers did say this, I don't know, that if this is a speculative development, in actual fact, at the time of the application, the council's Gypsy liaison officer interviewed many of the families that are prospective residents of this site. And that the Gypsy liaison officer then produced a schedule of families with their personal circumstances and notes of the interviews that they took. This was, I understand, considered as part of the planning application process. It's only just today been made available to me because it's not on the council's website.
So this is new evidence that I won't have seen.
Well, it's evidence that you should have seen because it's the council's own statement of personal circumstances.
Mr. Taylor was looking a bit quizzical. Would it be appropriate to have an adjournment? Have you ever chat with each other about this?
Yeah, I mean, I'm aware that we undertook a sort of a health and wellbeing assessment, which I've referred to in the report.
Right.
Obviously, we wouldn't publish that because there's probably some sensitive detail surrounding some of the individuals, but
right.
I'm not aware whether you've obviously not had a copy of that by the sounds of it.
No.
So I'm happy to get a copy of that, but obviously I just want to make sure that we are still talking about the same document. If we could adjourn just to double check.
Is that something, excuse me, Mr. Brown, shall we adjourn so you can just have a conflab on this? In that case, we will have an adjournment. How long do you need to talk? Come back. I suggest we'll adjourn. You could, Mr. Taylor, find somewhere to talk privately outside the room, and then when you come back, we will resume. Can you explain what it's about?
Yes.
Okay. Well, we will adjourn, and I mean it's time for a comfort break as well if anyone needs it. So we will adjourn. evidence that the main parties have chatted through? Who wants to lead on this?
If I may. Is that
Yes,
okay?
Mr. Taylor.
Thank you. Yeah. So I think so the document you've just been handed there, which the appellant also has now, essentially it is the location plan provided by the then agent, Mr. Carruthers, which sets out alphabetically each plot location. The following documents further to that was essentially the response from the interviews that our traveller liaison officer undertook as part of this planning application, which spoke to a number of the potential occupiers of the sites to understand their sort of particular circumstances, and that's sort of referred to in the officer report under personal circumstances, and essentially sets out their personal circumstances. I think just as a point of note, not all of the potential occupiers were able to be interviewed at the time, so there are some missing. So we have A, C, D, F, G. Yes,
B and H are missing from this list.
Yeah. So essentially that's provided us with the council with a bit more information on the individual circumstances of the applicants. And obviously that's then fed into the planning balance and conclusion nonetheless. Anyway.
Right. So this is late evidence. Mr. Kratz, have you seen this?
So I don't think anybody's seen it, apart from possibly the applicant, if they have seen it before now, and the local planning authority. So the public haven't seen it. So I'm in no position to judge the weight that should be attached to it.
No, I'm mindful to accept it. It's background information.
I would say the reason it's not public is because there's some quite sensitive details about individuals on there, so it's not really possible to publish.
Sensitive information. Just gives me a little bit of background. Anything to add, Mr. Brown, from your experience in dealing with many gypsy hearings?
It's the usual information that would be provided, but not necessarily made public.
Right. Thank you for that. Okay, so I have some information that I will accept and include as a hearing document, but it's sensitive private information that wouldn't normally be published in the.
And there is some additional. I've been through each of these.
Sorry, so just before my friend Mr. Brown says that, can I just ask what the date is of the document, please?
Mr. Taylor will help us with that, perhaps.
Yeah, I'm just going to try and locate it on our.
It's not dated.
Thank you.
The application was a few years back, wasn't it? Right. So it's a sort of less than a year old.
Yes, I have 18th of October 2022.
Well, I'm mindful to accept it because it's the sort of documentary evidence that's quite normally submitted with the Gypsy and Traveller proposals. It's, you know, it's background information and won't be considered, you know, an absolute.
Yeah, and apologies, it wasn't forwarded to you sooner. I hadn't realised it hadn't come across to you, but it was material, you know, we assessed.
You, the council, form part of your decision.
So, and again, I'm sorry, I just note that if it's October 2022, the application was actually March 2022, and that possibly explains why at the time the application was made, it was described as being market-led. So possibly after the application was lodged, the information was assembled.
Okay, so I've accepted it anyway. We'll move on. I think I
Did you want me to update some of the information?
How critical is that?
I think that it's worth you knowing the problems that these families are having in getting settled accommodation. Obviously, I'm loath to go into great detail anyway, because it's personal information, but some of the families have got more children than they had. The vast majority of children are of school age, and as an example, I'll just put it as pitch F, because then it's not identifiable to anyone else beyond those here. At the time this was produced, they were on a site in Willingham, and the site was overcrowded, so they were having to move. They have subsequently moved. They're currently squatting on a site in Wisbeach. They've got 4 children whose ages are 3, 7, 10 and 11 now. They've had no settled base, and because of that, the children have not had any schooling, simply because they've been moving around from site to site. The youngest child has got autism. He needs special help, needs care, needs special educational help, and he cannot get it because he hasn't got a settled site. As I said, site C, they've now got 2 children rather than the 1. Site D, I think one of the things that's
I'm wondering here, I mean, I'm not going to obviously cover this in any depth in what I write up.
right.
And this kind of information is considered and forms part of my case. Perhaps you could sort of provide your summary of this when I give you the last word before we finish.
Yeah, it's the general points which seem to apply to all of the prospective residents.
Because if I remember correctly, we were in planning balance territory, weren't we? And we'd interrupted Mr. Taylor. And given that you're going to get the last word anyway, we can go back to where we were. And before we move on to the more practical matter of conditions, whether you've got any sort of points on the balance to sort of emphasize for me, obviously all in your evidence.
Yeah, thank you. I mean, I think as obviously the planning balance is set out in the officer report and subsequent statements, and obviously having heard today what we've heard, the opinion hasn't changed. Obviously, I think we were satisfied as a council that the applicants met the definition of travellers. That's not been in question at all. And obviously, we acknowledge that there would be benefits in providing a settled base for up to 10 families, promoting access to health services and obviously, as Mr. Brown said, enabling children to attend that school on a regular basis. However, obviously, there are significant concerns in terms of the access arrangements and the failure to demonstrate that safe and suitable access can be achieved. Obviously, combined with that long-term significant harm to the countryside, and it's felt on balance. Obviously, even having regard to the best interests of the children, that securing a site which fails to demonstrate suitable and effective access, notwithstanding the long-term visual harms, that on balance the council is unable to support the proposal. And as I said, obviously having regard to the personal circumstances, that's not sufficient to outweigh our concerns.
Thank you, Mr. Taylor. So, Mr. Brown, back to you.
Starting off with gypsy and traveller sites, as I've said, are going to be in the countryside. That's recognised in government and local planning policies. So you have to accept and expect that there will be a change in the character and appearance of the countryside. The test has to be, is the change so unusual and so harmful in this case that planning permission should be refused for that reason? And I don't see anything unusual in this case which makes this site so much worse than any other site in the area that planning permission should be refused. In fact, quite the opposite, because this site, unlike others in the area, is situated within an area which is not typical of the Fens. It is well enclosed by existing hedgerows, existing woodland, and by other existing physical features. So that, in my view, there is no unacceptable harm associated with the development. Certainly no unacceptable harm that can't be adequately mitigated with additional landscaping. And there is more than sufficient room within the site to achieve that landscaping. As far as the other main issue, access, is concerned, it's only a theoretical objection. In reality, clear visibility is available and likely to remain available. There's no likelihood that anything is going to happen to those drainage ditches. They are required, as they are in all of the Fens, for the drainage of the land. So neither of the council's two main objections, in my view, should persuade you that planning permission should not be granted. On the other side of the balance, there is clearly a need, an unmet need for traveller sites, which is likely to be significant. I set out in my evidence that 13 planning permissions have been, or permission for 13 pitches has been approved up to the date when my evidence was provided. That may or may not have increased by 3, according to Mr. Kratz. But 16 pitches is nowhere near the 50 that was required just looking at the out-of-date GTAA. The GTAA is likely to be a vast underestimate of need in this area. So you have unmet need, you have acknowledged lack of a 5-year supply. So if you find there's a need, there is nowhere for that need to be met. The council can't suggest any alternative sites for these families. And at the present time, these families are having to go from one site to another, mainly overcrowded site to another, where they've got no security of tenure. So they're constantly having to move from one site to another, which means that they can't get adequate healthcare, can't get adequate education for their children. There are numerous children that could be living on this site and gaining access to education and healthcare that are not doing so because they haven't got a settled site. There are numerous people on the site who have special healthcare needs, and you have some details of that with this schedule that you've been provided with, where they not only need specialist healthcare assistance or access to it, but they also need the support of their close family members, some of which will be on this site, but some of which is living close by. Several of these families have got other family members living in the Witchford area, and they're reliant on those family members for support. They can't get it because they're not living in the same area or not on any consistent basis. They're all factors that weigh in favour of the development. So even if you found that there was some limited countryside harm, then you should still grant planning permission, because what is the alternative? The alternative is a very unhappy place for the families involved. Thank you.
Thank you for that. So that's helped me with those summaries of the opposing views on how the planning balance might be struck. I think we can now move to the more prosaic matter of conditions. I did notice that the Leeds Local Flood Authority had recommended a condition that was missing. Is that something you'd picked up? Or more than one condition?
Yes, they've suggested two conditions. One is obviously a site-wide drainage strategy for future operation, and one is essentially a drainage strategy for during the construction to sort of ensure that any surface water runoff during construction doesn't affect water courses. That has been missed off of the schedule of conditions. So I think that probably would.
I didn't notice any others missed off.
Only that the Environment Agency had suggested flood resilience measures to be built into the units, into the caravans themselves, which in my experience is usually the requirement for them to be sort of anchored down, and a scheme for that to be agreed, but they've not sort of explicitly set that out in their comments.
Could you provide a condition suggested? Would you mind providing an agreed condition to that effect?
Yes.
If you wouldn't mind.
Yes. I think I may have one on hand. Let me just see if I can find one, if I may.
It's one you prepared earlier, is it?
I may not be able to find it. If not, I'll have to go.
Don't worry. Don't worry. Should we just leave that, park that one? It would be helpful, put it that way.
So as an observation linked to that, there's no condition requiring the evacuation plan that was referred to by both parties indeed.
Yeah. No, that's a good point.
And so whilst I've had the mic on, the plans condition, of course, reflects a block plan that the local highway authority have said isn't man enough for the job because it doesn't provide adequate turning circles. So to approve the block plan, which is not
There
adequate,
need to be a condition, something along the line of notwithstanding, and I think that's
Yeah.
legitimate.
I think it just needs to acknowledge the fact that the block plan needs amending
Yes.
to take account of the need for internal manoeuvring so vehicles can enter and leave in a forward gear.
So you've helpfully suggested, I think at least 2 conditions, possibly 3. There's a condition that would cover the evacuation plan. You've suggested was that your condition?
So I think in terms of flood resilience, we would be looking at sort of anchoring plus the evacuation plan to be
Yeah.
agreed.
So I would be grateful for the wording agreed between the main parties over that and a condition covering that turning area point.
Well, you could, if you were requiring the submission of a site development scheme, you could include within that that we would have to show as part of that scheme adequate car parking and facilities for
I
vehicle
could, but
turn.
I could also ask you to help me with it because I spend
Oh, yeah.
conditions can take in the event of an appeal succeeding, which isn't guaranteed. Writing conditions can take days, particularly if the council gives you large numbers, which you haven't done in this case, but
No,
councils usually do.
if I could just refer you to proposed condition 11 on that schedule.
Yeah, seems to be along the right lines, doesn't it?
However, so whilst I'm switched on, the landscaping condition doesn't require compliance. The usual sort of, and any that die within 5 years shall be replaced. So
Yeah.
I'd suggest that needs that as well. Otherwise, it's simply a piece of paper.
Along the usual lines of any shrubs that fail within 5 years should be replaced. Yeah, we all know it, don't we? Should we start at the beginning and just go through? So we've got anything to say on the plans, otherwise, although there would need to be some refinement, we've already talked about in terms of turning areas. They're the plans agreed. Can I tick that condition number 1? I'm looking principally at you, Mr. Taylor, if you don't mind. Condition 2 is the standard 3-year time limit.
Yeah, and obviously it's whether or not we consider that development has already commenced, as Mr. Brown made reference to earlier. It's obviously the use of the land, which is the primary matter, but nonetheless, there is some operation development that's required to support it. So
it's the use of the land that's being applied for, and any other development is associated with that change of use. So the change of use has not commenced, and therefore there is no lawful development that has taken place associated with that change of use. So the development has not commenced, and the 3-year time limit is the appropriate time limit.
Okay, I'm not going to prolong that argument. Number 3 is specifying the number of pitches. So that seems.
Specification of the number of pitches is not a problem. If you look at the schedule of families, you'll see that they set out what their accommodation needs were in that set schedule. And I'm not sure how much you can take this into account, but some of the families needed additional caravans. For example, Lavinia.
I think it's difficult now. I've got a signed statement of common ground with these conditions signed up to.
Well, as I've said, this has only just come to me.
It has.
And if you read through, you'll see that, well, Lavinia, for example, has got 10 children. She needs more than one static caravan to accommodate those in.
That materially changes the proposal that was before the. I mean, I'm taking that information that I've accepted as documentary evidence of a general need.
Yeah, well, as I've said, I don't know how much you can take the family's requirements in for extra caravans into account because of the way that.
I think to my mind, it amplifies your argument over the need for accommodation. I think if we're going to start chopping and changing the number of caravans, I think that would need a fresh application. Otherwise, I don't want to deal with a movable feast. You've signed up to this condition. I think if I was mindful to allow the appeal, that would be a condition I imposed, and then you would just have to, in the event of the planning permission be granted, you'd have to move forward and see if you can.
Well, from the way that the application was submitted, I don't think that you can't change the nature of the development through the imposition of conditions. So.
Right, condition 4 touches on the definition, and this is now, I believe, sometimes altered by other inspectors based on Smith. Am I right or wrong? Yeah. So is this the kind of updated condition based on or permanently? Good. Okay. Sorry, I was thinking out loud there. I have obviously read these through very carefully previously. Number 5. No commercial activities. It's a fairly standard one. Number 6, I agree with, is requiring details of external lighting. 7 is the landscaping scheme, which Mr. Kratz has reminded me would need the standards of compliance paragraph. Condition 11 is setting back. Is there going to be a gate? Well, anyway, that this condition makes sure that if there was, it's set back a minimum of 8 meters. So I'm taking that as read. Biodiversity. We're not going through the whole hog of the 10%.
No, I don't think
This
we
is a
are able
pragmatic
to
one, isn't
ask
it?
for that.
Yeah. 10 is contamination. Not thinking it's probably very likely is on a site like this. It's farmland.
It's an unsuspected contaminated land condition, so it doesn't require any front work.
No, I realise that. Yeah. So 11 we've talked about. So that just leaves the lead local flood authorities conditions, which I've got, and you're going to suggest the wording of a couple to cover the flood resilience.
I'm happy to read that out now, or unless you want to
Send it to Bristol.
I don't know whether the appellant might want to agree.
Yeah, if you could
Or
agree
not.
it with Mr. Brown over lunch.
Yeah, happy to do that. Thank you.
So that was a scamper through the conditions, the important part of a hearing. Anything on, Mr. Kratz, you happy? Have you kept?
Completely happy, thank you, sir.
Yes. So it's coming up to 1 PM, which was my thinking of a possible time for finishing. Not heard any costs made, so we've had final word on the planning balance. I don't think is there anything that very important that might have been missed. I don't think there is. So let's move on to the site visit. What time shall we have it? Can we have it? I mean, I'd like it sooner rather than later, but we need to eat a sandwich and things like that.
Yeah, obviously just got the
Get to the
conditions to
site.
discuss, get to the site, which is 10 minutes away, I guess, plus a bit of lunch in between. So
Should we aim for 1:45 and start when everyone's arriving? Where shall we park?
is there a possibility to park on the site?
Are you happy with that then? Yeah. Okay.
As I said, I think it would be prudent with respect to just walk along that right of way if we can.
Yeah. My thinking was once we've found somewhere safe to park and look at the access, we can then work out our itinerary based on what I think we've discussed the points of view, you know, including the right of way and the Grunty Fen road points. But I think once we've parked and looked at the access, we can then go and look at those. So, and some of those things I can do on my own, can't I? Yeah. Mr. Kratz, are you happy with that?
So yes, for the avoidance of doubt, I won't be coming to the site visit, but
You
I'm
won't.
more than happy that you can be shown where Woodlands is. It's signposted from the road leading down to Pools Road, and I'll leave it to your discretion to go there. on your
Okay,
own
I
would
think
be
we'll
best.
aim to look at that either on my own, but if it can be pointed out by colleagues here. And so I'll be accompanied by you two and Mr. Brown, and Mr. Brown's client will kindly open the gates. And so on